SJC-12319, Commonwealth versus Mack.
All right, before we start, Ms. Demon, good morning. As I think you saw this morning, your sister had a fall, and so we're going to allow her to sit during the course of her part of it.
Of course,
we will do our reasonable accommodation for those who hopefully are only temporarily disabled. All right, we'll hear you.
Thank you. May it please the court, my name is Sharon Demond, representing Mr. Eddie Mack. If I may, I would just like to briefly start by addressing the inadvertent omission of the trial judge in conducting voir dire of the 7 impaneled jurors on the first day of the impanelment, where the judge did not ask any questions whatsoever about possible media exposure, pre-trial exposure.
That's not statutory, right? That's a matter of discretion?
It is a matter of discretion, Your Honor. However, case law is extremely instructive on that, and this court has held a number of cases that when there is pretrial publicity, that the best way to go about finding an impartial jurors is to go in an in-depth voir dire of the potential jurors.
So my memory was this wasn't really raised until the experienced judge looked around and said, Jesus, somebody from Cape Cod Times here. I better do it going forward.
That is correct, Your Honor. However, as the docket reflects, 14 months prior to trial, there was pretrial publicity. There was an interest, there was a motion filed by the media outlets for their presence for a motion to suppress hearing. 2 motions, one of which was a motion to suppress identification of Mr. Mack. In fact, there's media coverage here today.
Does the judge have any reason to know about this, though?
I would suggest to the court that the judge resides in that district or in that superior court, and that is the judge of the county. Case law has said in at least one of the cases where it was Nantucket that where the court is aware of the small community setting that he is in the best position to know that there is media coverage. Now, this is Barnstable County. This is a very highly publicized murder that happened in Barnstable County. Again, looking at the docket sheet, there was an interest 14 months leading up to the trial that there was media coverage of the motion to suppress identification.
In the scheme of things, was it really that highly publicized compared to McGowan in the Nantucket case?
Well, I suggest to the court it's relative, and it all depends on whether or not the jurors were exposed to it. Now, looking at the record, the first day of the impanelment, there was presence in the courtroom of the reporter. The judge also cites an article that day or some sort of police log that day in the newspaper. So there was coverage that day. Then the second day of the trial, the judge comes back and there are newspaper articles. There are 9 pieces of identifying evidence as far as newspaper, media coverage. In fact, at some point it was picked up by national news, Boston Herald. So it was publicized. Whether or not it was as publicized as McGowan, it's all relative, I would suggest to the court, but it was definitely publicized. And those 7 jurors, 5 of which were in fact deliberating jurors, decided this case without any inquiry as to whether or not they saw anything about this case.
Don't we have to have at least some evidence that they were exposed to this? I mean, yours is purely speculative, right?
Well, no, Your Honor, it isn't speculative because
because there are stories in the Cape Cod Times doesn't necessarily mean these people actually saw them or there's any suggestion that they saw them, right?
Well, these particular 5 jurors, no. However, the record clearly reflects that other jurors certainly had seen it. The second day, at least 7 jurors said they had seen it, only 1 impaneled. The third day, there were more jurors that had said they'd seen it. 1 juror said he saw coverage a week before. Now, whether a week before is 7 days before, 5 days before, 6 days before, what have you. But again, there was coverage, and some of the jurors had seen it without any kind of inquiry. I would suggest it's analogous to the Korean case where this court held that there was publicity, there was no inquiry, then the assumption is they saw it. So I would suggest to this court that analogous to that case, if there was no inquiry whatsoever, then the assumption should be that...
In that case, was there any evidence that they'd actually been exposed to the, I mean...
No, Your Honor. In that case, there were newspaper articles. The judge refused to poll the jurors.
So he was asked to poll and refused?
Yes.
So this case, we don't have anyone asking him to poll?
No, it was
So it was
essentially inadvertent. It was inadvertently done because the importance of which was obvious to both the trial judge and counsel once they knew it. So it's inadvertently omitted by the trial judge.
I've not gone back to the record, but am I correct that the substantial publicity occurred on day 2 of trial?
I don't agree to that, Your Honor.
I'm sorry?
I do not agree to that because the docket reflects there was publicity 14 months before the trial.
Okay, I understand that there was some.
Right.
But,
And then the day of the
but
trial.
in terms of, I mean, there was a reporter in the courtroom for day 1.
Yes,
These 7 jurors, 5 of whom are deliberating, are chosen on day 1.
correct.
And then, for whatever reason, on day 2 in the morning, the Cape Cod Times, I gather, has a major story.
Correct. However, on day 1, there was at least one police blog, log, what have you, noted by the trial judge that it was on day 1.
Which said what, by the way?
Well, it's not apparent on the record. The trial judge essentially says there was a police blog that just talked about the charges in this case. It wasn't elaborate. So that's about it.
So there's no
There's not much about it.
There's nothing to indicate that that police blog would have told these jurors anything more than they would have learned from the fact that these people are on trial.
Not based on the record, no, Your Honor.
And at the end of day 1, where these jurors were selected, did Judge Nickerson provide any guidance to these jurors about reading the paper or anything else?
Yes, Your Honor, he did.
So he told them after day 1, you folks are chosen, we're going to continue the case tomorrow. I mean, again, I didn't read it, but I know Judge Nickerson, who we all know to be a very fine judge. So if I expect that what it was said is, you're chosen, come back tomorrow morning, we're going to finish selection of the jury, you should be careful to not read anything about the case.
It would be correct.
And then in the morning, did he take those jurors and says, have you read anything about the case?
In the morning, the jurors didn't come back. He asked them to come back at noon because they were still impaneling. So the next day is when he starts voir direing about media exposure. And when the jurors came back and they had impaneled, I believe, 4 more jurors, if I'm not mistaken, at the conclusion of that impanelment, he brought back the 7 and then instructed again pursuant to what Your Honor just stated. But he did not go back and said to those 7 jurors, did you have any kind of media exposure prior to being impaneled in this case?
And in the morning of each day, did he ask the jurors, have any of you read anything about the case?
Yes, he did, Your Honor.
And no one raised their hand.
Correct, Your Honor.
So we at least have some indication that even those 7 jurors, now, again, arguably you could argue, well, they thought he meant only that morning, but
Precisely.
no one has raised their hand to say we've read anything about the case.
Currently, yes, Your Honor.
And there's nothing in the coverage that indicates that extraneous information, I mean, you've not presented us with any newspaper articles that contained information that wasn't presented even at trial, right?
There were pictures, as referenced in the trial record, and as
What?
pictures of both defendants being in handcuffs and coming out of the van. There was one newspaper article, it was towards the conclusion of the trial, that the trial judge also says is troubling and marked for identification. All of those, the 9 articles in questions were all marked for identification and part of the record. But again, looking at those 5 jurors that ended up deciding this case, we have no way of knowing whether or not they were impartial at this point. And I suggest to the court that the presumption should be in favor of Mr. Mack. If there are no further questions, I'd like to address the cell phones, if I may. Looking at the search warrant, the issuance of the search warrant for 7295 number, which is attributed to Mr. Mack, suggests to this court that there was no probable cause for the issuance of the search warrant.
Address the Webster case?
I'm sorry?
Can you address the other case?
The other,
Commonwealth versus Webster, the case we decided, I'm the co-defendant
yes,
recently.
okay. And what would you like me to address on that case?
I thought we had, maybe I'm wrong, I thought we had discussed the cell phones in that case.
Your Honor, you had discussed the 9676 number and whether or not it was properly authenticated.
Okay.
However, there was no issues raised pertinent to Mr. Mack's issuance of the search warrant.
Thank
Okay. There was no There was no issue about whether or not there was sufficient probable cause to issue the search warrant, if you will. So in this particular case, I suggest to the court that there was ineffective assistance of counsel for failure to file the motion to suppress.
Even though Mr. Mack is found with 4 phones, right?
Yes.
And there's all kinds of information that you've got 4 different co-defendants, you've got 4 phones, they're meeting up from different places. It's not
But that's not known at the time of the search warrant, Your Honor.
Well, but
So
it's
at
no-
the time of
it's-
the,
it's known that there are 4 co-defendants, there are 4 phones found in 1 bag, which is odd. And isn't there a probability that that's going to turn up meaningful evidence?
I disagree with that only because at the time of the search warrant,
So
there was no.
Even though some of the co-defendants are coming from Boston, they've got to, collaborate.
But that's not known at the time of the search warrant. The probable cause for search warrant begins and ends with the 4 corners of the affidavit.
Right.
The affidavit, at the point, the affidavit has 3 suspects, not 4, Your Honor. At that point, the 4th suspect is not known. They know 3 suspects, they know 3 people jumped over the fence and ran away. All 3 are in custody. They're not looking for a 4th person at this time. Looking at the 4 corners of the affidavit, all it says is that in the common knowledge of the officer, cell phones are used in commission of the crime, which we well know by now. This court had decided is not enough, so the Supreme Court. And the only other evidence that is cited in the affidavit is that Kiko Thomas said he received a phone call from Mack the morning of, not anywhere near close to the shooting, the morning of the incident, saying, I am at the deceased's address buying marijuana. Now, Mack and the deceased are friends. Mack has been at the deceased's house a number of times. The deceased is a known drug dealer. So I would suggest to the court the fact that Mack is at his friend's house, known drug dealer, buying marijuana, hours before, in the morning, that one phone call is not enough facts. It's not enough particularized facts to suggest that now we can just get a search warrant and search the phones.
You don't think the police had reason to believe that this was some type of drug ripoff involving multiple parties?
It could very well have been, Your Honor, but just because there is a general knowledge.
That's how it played out, right?
Yes, that is correct. But just because that is a general knowledge of the police know that, that's a generalized knowledge. That is not a particularized fact to this case. And again, this court has had a number of cases that it's a very fact-specific inquiry. And in this particular case, at the time of the issuance of the search warrant for Mr. Mack's phone, there was nothing known of a 4th subject. They knew 3 people jumped out. They got all 3 people. They found Mr. Mack with 4 cell phones. They also found cell phones at the address. So it wasn't like in line with Holly case where they found the victim with no cell phones on it, and there was evidence that he always had his cell phones on him. They found the deceased with 4 other cell phones. So there were 4 cell phones found near Mr. Mack. There were 4 cell phones found at the address.
4 cell phones found, 3 men seen fleeing. One of the cell phones is the number they're trying to look at, Mack's phone number.
Precisely. And that's what they got the search warrant for.
And we have a murder.
That's all we have. We have a
And we have
murder.
also a car that's disappeared.
Not at that point, Your Honor. At that point, we don't know anything about the car. At
They
the
don't
time
know,
of that
they
search.
don't know that there's a car present at all?
No, if you look at the 4 corners of that affidavit, there's nothing about a car. They know that the 3 people went there. They know 3 people escaped. They know 4 phones found by Mr. Mack or under the pallet or in the alleyway. They know there's a murder. They know there's a body, and there's 4 other cell phones at the house.
I don't think that's enough for probable cause.
No, Your Honor, I don't. I think that there needs to be more facts associated in order to pass muster of probable cause. If that were the case, arguably any case where there are co-defendants running from the scene and they're found with cell phones, then we can just jump to the conclusion that they must have been using the cell phone. So how is that different that the general knowledge of the police knowing that all co-defendants use cell phone in commission of crimes? That essentially is the same generalized statement without more specific facts, which is missing. This search warrant did not have sufficient probable cause to be issued. Now, after the issuance of this search warrant, then they look at this 7295 number, Mr. Mack's phone, and then they discover the 9676 number. And that's how they come across the 9676 number. And if you look at the affidavit associated with the search warrant of the 9676 number that they're attributing to Mr. Evans, the search warrant says, other than what they saw in Mr. Mack's phone, they did not know of this 9676 number. So at that point, I suggest to the court, that becomes the fruit of a poisonous tree, that if this court were to hold that there was insufficient probable cause to issue the warrant for Mr. Mack's phone 7295, then it follows that what they discovered in Mr. Mack's phone, which was the discovery of 9676 number, that then they get a search warrant for, cannot be presented as evidence in this case as a fruit of a poisonous tree. Now, separate from that argument would be what this court addressed in the Webster case, is that even if this court were assumed that there was probable cause and they got the 9676 number, it still would not be properly authenticated to be introduced to the jurors. Now, this court held that because Webster said that Trigger was the street name for Mr. Evans, then, and TR was a contact name in Mr. Mack's phone, then it can be inferred that it's one of the same person. I would suggest to the court there are a number of problems with that. First, if you take a close look at the
It was the same evidence, though, right?
yes, the same evidence. The two
And
distinctions.
we were wrong in Webster?
I'm sorry?
We were wrong in Webster.
Respectfully, Your Honor, if you look at the transcript,
You can say we were wrong, that's fine. People say that all the time.
We're not final because we're infallible. We're infallible because we're final, right?
what I'm saying is, if you look at the trial transcript, it is true that they say, do you know Evans? And he says, Mr. Webster says, I don't know Evans. Then the police officer says, Trigger? He says, I know that individual. Nowhere he says that individual is Evans. I think it's a leap for this court or any other court to say, he said, I don't know Evans. Then the police officer says, Trigger? Says, yeah, I know that individual. But that doesn't reason that, okay, Evans is now Trigger. That is not a conclusion that can be reached. And that is what was said in Webster's holding. Now, even assuming that was the case and that could be reasonable, that could be a reasonable inference, in Mr. Mack's case, the Webster's statements after joint venture had ceased would not be used against Mr. Mack. And the trial judge instructed so, that whatever Webster said at the time of arrest, which was days after this joint venture had ceased, could not be used as evidence against Mack. So I suggest to this court, even if it could be inferred that he meant Trigger was Evans, it goes to Mr. Webster's case, not to Mr. Mack's case, because what Webster said was not part of joint venture and could not be used in Mr. Mack's case. So, again, at the risk of being repetitive, if we were to make the link that Trigger is Evans, and then make the second leap that TR stands for Trigger, where nobody said TR stood for Trigger, then we can't use that as evidence against Mr. Mack. So I would suggest to the court that Mr. Mack's case differ from Mr. Webster, and the judge should have allowed the motion to strike after he allowed the evidence de bini, and then the evidence did not come forward to link 9676 to Evans, because neither Nassif did not testify. She was held in contempt, and Cotel had nothing really to add. She authenticated her own phone. So there is no authentication of the phone to even be put before the jury.
How about all the evidence that your client was there? He's seen leaving, they identify him, he's all over the place here. It's not like there's not a huge amount of evidence that your client is participating in this murder, right?
Well, my client was at the scene where he was with a friend. Mm-hmm. There is evidence that he was there quite some time. He was always there. He spent the overnight. So there's nothing incriminating about his mere presence there.
Well, he's hiding.
He's hiding in an air conditioner, right? He's caught
Yes,
hiding
he is
in an air
found in
conditioner.
an
Why
air
is he hiding in the air conditioner?
Perhaps he saw the first opportunity to escape. Maybe he was there with his friend and got caught up in this whole thing.
And there's all this incriminating evidence right near him?
Yes.
Okay, that's a problem.
He's found right with the $14,000 and all the marijuana?
Yeah, but that is not evidence of murder itself. That's evidence of perhaps taking an opportunity and stealing something and running away with what he stole or what he took,
It
but
could
that
be a
doesn't by
piece of
itself.
evidence, though. It could be a piece, right?
Yes, it could be a piece, but by itself, if we were to suppress the cell phone contents and the 9676 numbers introduction, then by itself, it wouldn't be sufficient for this court to hold up the murder conviction.
Okay, thank you.
And I see that I'm out of time. I rest on my brief. Thank you.
Thank you so much. All right, Ms. Sweeney, how are we going to do this? Want to move the microphone to you?
They
She's
gave me
got
a
a
microphone.
got a microphone.
Here. Everybody's been very accommodating.
Okay, we're trying to be. Okay, you may begin.
Good morning. May it please the court. Elizabeth Sweeney for the Commonwealth. Turning to the first issue, the defendant's right to an impartial jury was not violated where there was no media exposure for the first day of jurors. Whether or not to inquire for jurors about media exposure is the judge's discretion, and here Judge Nickerson did not abuse his discretion. The record reflects that on day one, nobody brought up the issue of media exposure of the Cape Cod Times. The jurors during individual voir dire were not asked about media exposure. Judge Nickerson did note that afternoon, he said, I do see a reporter from the Cape Cod Times here. There is likely to be an article in the newspaper.
It's a pretty big murder on the Cape, right?
Comparing it to other homicides on the Cape, I actually would respectfully disagree with that point. I think that there are other homicides, for example, Thomas Tulin on Nantucket or Christopher McCowan, that had significant more media exposure. This case actually was from 2012 to 2016, 4 years, and there was only 2 requests from the Cape Cod Times to attend and publish an article or request that their presence in court. So during 4 years, they only requested the docket request twice. 2 appearances. So I don't think that rises to the level of comparing it to McCowan or Tulin.
As part of the routine jury instructions, did Judge Nickerson ask whether anyone knows anything about the case?
In the morning with the general jury, when they brought them in, yes, there was the inquiry to everybody, the standard instruction that you would do. But the defendant's claim is that there was no individual voir dire asked to everybody that morning. No one requested it, and that's to the judge's discretion. He did the next day have the newspaper removed from the jury room, and then at the end of the day, with all the jurors said, do not pay attention to the Cape Cod Times, stay away from media, turn a blind eye, I think was his exact words, to newspapers, and continued that instruction as the trial went on and continued.
Do you have in front of you the standard instruction he gave? Do you know what it was?
In front of me, no, I did not bring that today, but it's the boilerplate, I suppose, instruction that one would give on the first day of a jury impanelment. And the issue that defense counsel raises is the individual voir dire for everybody that morning. But as soon as there was an article published that evening, he, for day 2, started inserting that question with every juror the next day. And they were all instructed, and jurors are presumed to follow the judge's instructions to stay away from media. Turning to the second issue that defense counsel raised today, the search warrant for...
Well, before you switch, so what do we make of the fact that, so that standard instruction's given, right? The standard boilerplate instruction. But even some of the people who later raised their hand saying they've been exposed, or are they exposed to later? A couple of the jurors, potential jurors, we know were exposed to some of the publicity. One person was kicked off kicked out of the pool, right?
I believe that was not on day 1. I know that on
So
September 12th.
They were exposed to something subsequent that's why they were not picked, is that right?
If we're talking about the jurors that raised their hand and said I was exposed to media,
Right.
or during an individual voir dire raised that issue, that was on the first one that defense counsel noted in her brief was September 12th. He said that he saw an article the week prior.
So I guess that's my question. So the boilerplate doesn't get any reaction at all, right?
No.
And now, as we do the individual voir dire in the later days, it actually turns up people who'd been exposed to stuff beforehand, right? Do we make anything of that?
I suggest this court that that is only a reflection of the fact that the Cape Cod Times started attending the trial on day 1 of the jury being impaneled.
But I thought you said it's an earlier story, like a week ago story.
Correct. So September 12th was the, I want to say, I can't count, maybe the 5th day or 4th day of jury impanelment. And he states, I saw an article in the Cape Cod Times the week prior. And the record reflects that the Cape Cod Times started attending the trial on September 7th and 8th. So it's the Commonwealth's position that possibly he was referring to the article that the Cape Cod Times published when they were in the court for the first day of jury impanelment. But we have no evidence as to what article he's referring to. But when that juror brought up that issue, again, that was due to the judge doing the individual voir dire as soon as there was a reporter seen in the courtroom.
Does the record reflect the Cape Cod Time articles?
All the articles were introduced and I believe marked as ID.
Okay, so we have those.
Yes. Turning to the cell phone issue, the search warrant for cell phone 7295. As a preliminary matter, when the police did the search warrant for the cell phone, they did not know the number. The phones were found with Mack, who was hiding behind Luke's Liquors, by some air conditioning units and some pallets, and he had multiple phones with him. So the police gathered those phones and they did a search warrant, and in that search warrant, they stated that there was a phone call between Mack and Thomas, two co-defendants, and Mack said he was at the victim's house buying marijuana from him that morning. The shots were fired and police showed up to the house at 1:20 p.m. that afternoon. So shortly before the shots were fired, hours before, the defendant and the co-defendant stated that Mack was at the house buying marijuana from the victim. Therefore, if you apply the court's analysis for cell phones and probable cause, that there has to be a crime committed and a nexus between the
Does the
cell phone.
affidavit make clear that it was a potential drug ripoff?
The affidavit does not necessarily get into the drug ripoff
Does
because
it say that the victim was a marijuana dealer in the affidavit?
it does not say the victim was a marijuana drug dealer. It states the basic facts that there was a homicide, that individuals were seen fleeing from the house, they hid, and that Mack was found with these 3 cell phones hiding.
Did it say
And
that there was a robbery?
It said that there was a homicide, and that's the facts that they get into, and that Thomas, Mack, and Evans were observed by police. The police knew who they were at that point, running from the house and hiding in an area near the house. So at that point, you have the facts and search warrant that these police were leaving, the people were leaving, and that they had communications with the victim that morning, that Mack was at his house that morning buying marijuana. So you have a nexus between the defendant using his cell phone to talk to a co-defendant and putting him in the context and location of the victim. So you have the usage of the cell phone, that the co-defendants are communicating and that the defendant, Mack, is at the house with the victim. And the defendant was found with these cell phones. We didn't know the numbers of the phones at that time. We just knew the defendant was found with these phones. And if you look at the search warrant, the trooper writes that he wants to search the phones to figure out the identity of parties involved because there's these communications about buying marijuana. And there's probable cause to determine the identity of these people, of what's going on, of who the phones belong to, who they're attributed to, and also the numbers. And so I suggest this court that there was sufficient probable cause. This search warrant is a far cry from the Onyx White issue. The search warrant doesn't say that people communicate and text each other, and therefore we have PC to search and see the contents of the phone. There's specific facts that the co-defendants were talking about, buying marijuana from the victim at his house, and then 3 hours later, we have a homicide. And turning to the 9676.
Sorry, I don't think it said the time. I'm looking at the affidavit. Thomas stated that he received a phone call on his cell phone from Edward Mack on the morning of July 11th. Does it, I guess, identify the shooting was on 1:23 p.m., so your inference is that it was within a number of hours of the 1:23 shooting.
Yes.
And so basically, Mack says, I'm at the house of the person who turned out to be the victim. The affidavit says the victim was basically bound and found dead with his hands bound. So it's not just a routine shooting. They bound him. They
It's
appear to have bound
absolutely
him
not a
first, and then they
routine
shot him.
shooting, but it's a homicide where there's multiple individuals involved and multiple phones.
3 men are seen fleeing after the shooting when the police come, and the 3 are Mack, Thomas, and Evans. So the person who Mack called to say, I'm at the house buying marijuana, was one of the 3 who was later found fleeing the home.
Yes, Kiko Thomas, he actually ran up to a sergeant and said, "Help me, sergeant, they're trying to kill me." I don't believe that's in that search warrant, but he's a co-defendant.
Okay, that's not in the affidavit.
Correct.
So the affidavit just simply says 3 men were seen fleeing, the inference being that they were fleeing because they were involved.
Correct, and the search warrant states that they're trying to determine the identity of the persons involved. So therefore, there's probable cause based on the statement of Mack and Thomas having that conversation about Mack being at the victim's house that morning to buy marijuana.
And I think your sister is correct that there's no reference to a 4th person in the affidavit.
At that point, they did not know that there was a 4th person, so that would not be in there. They only arrested 3 individuals at the scene. The 4th person, Stephen Webster, whose case this court decided in July of 2018, his identity or his even presence was not in light at that point. Turning to the issue of the 9676, that issue involving whether or not that phone belonged to the co-defendant was addressed by this court in Commonwealth v. Webster, and I suggested that this court's holding in that case was correct. There was sufficient confirming circumstances that the 9676 number belonged to the co-defendant. Lastly, the name trigger was properly introduced. If this court reviews transcript page 1314, the audio of the interview was introduced, and the trooper read the conversation to the jury. And the trooper said, "You don't know David Evans," to the co-defendant Webster, and he said a lot of people go by street names, and the trooper suggested Trigger, and then he said, "Yes, I do know that individual." So I suggest that based on the record, there was sufficient evidence that his street name was Trigger. And if there...
And why help me with that? I mean, your sister says that he merely said that, yes, I know Trigger, but did not say that I know Evans to be Trigger.
I think that the reasonable inference from the way the questions flowed establishes that David Evans is Trigger. The defendant, the co-defendant, says basically that a lot of people go by street names. I don't know, people's, I guess, regular names. And so the trooper suggests Trigger, and then he agrees that that is yes, I do know that individual. It's a reasonable inference based on the statement by the trooper that they're talking about the same individual. He asks for his street name and he provides it. If there are no further questions, I rest on my brief.
All right?
Thank you.
And we'll help you get out of here.
I should be okay. I'm so sorry.
Don't be sorry. We're sorry it happened.